Welcome everybody to this webinar on COVID-19 and employment law. These are, well, weird times, so to speak. At Höcker, we are just getting used to working from home and basically combining that with for many of us, with the care of children, etc. So it's weird, especially if you see the news every day. Although today I think there were some positive notes on the development of at least of the number of deaths and in the Netherlands. My sound is off. It should be on right now. Can you hear me? Can a couple of people? Yeah. All right. Okay. Sanet says my sound is off. I think you should check your speakers. I'll type it in the chat. Check your speakers, please. Welcome again to this webinar. I'm here with my colleague Nick Herks, who is at a safe distance of 1.5 meters away from me. We'll discuss with you a number of topics on employment law in relation to COVID-19. You've already, a couple of you already found the chat function. I've disabled your audio and video options, but you are still able to chat. So we'd like to make this as responsive as possible, as interactive as possible. So if you have questions on certain topics, do put them in the chat, and we'll see if we can answer them when we get to the specific topic. We have scheduled this webinar to last for 1.5 hours. Usually it takes about 1 hour and 15 minutes. So for your planning, if you at some point have other things to do, well, no problem. It's a webinar. You can just go away. We'll of course appreciate if you stay until the end. We'll also be recording this session, and we'll make sure that the recording is distributed afterwards, so you can check what we've told you. All right, that's it. I've shared the presentation. You see we have a number of topics: the duty of care, Ebe, which is a translation of the Noodmaatregel, and so the emergency measures that the government is currently implementing as a result of the crisis. These measures in relation to reorganization, topic disability and privacy, working at home, and some other topics we couldn't put into one of the above. I see that there's a question about staff holidays that you'd like to ask. We'll get to that because that's one of the questions that was asked many times. Let's see. Start off with the duty of care. So duty of care is the English translation of the zorgplicht. In accordance with Dutch law, employers have a duty of care regarding to the working conditions. So you should make them as safe as possible. This means that concrete examples of this duty of care could be, if you look at a factory, for instance, that people should wear helmets, that you have certain instructions as to how to manage equipment. If you look at, for instance, an office situation, there are certain indications as to the height of a desk to prevent RSI, so to prevent employees from falling ill as a result of bad habits and how they sit. Around Corona, some of the standards, some of these the standards that you would relate to the duty of care are basically met by the guidelines of the RIVM. That's the institution that advises the Dutch government on the Corona crisis. They determine what can be required of a reasonable acting employer. And in this context, employees will have to be properly informed about the symptoms of the coronavirus, the applicable hygiene regulations, and also what to do in the event of health complaints. I will list these They probably have heard them many times before, but they're relevant because as an employer, you should communicate them to your employees as well. Wash your hands regularly, cough and sneeze in the inside of your elbow, use tissue paper, do not shake hands, stay home if you have a cold. Also stay home if you have a sick family member. Do you have a cold or increase, so an increase of your body temperature, 38 degrees Celsius, stay home. Make sure that you don't affect others, keep a distance from people. Then if you have a fever, so over 38 degrees, and if you cough or breathe hard, then you should call a GP or GP post. It's also wise to impose restrictions to employees when it comes to business trips. So they should at least not have trips to countries that have been color-coded red or orange by the Ministry of Foreign Affairs. Also, you should impose restrictions with regards to meetings. Replace face-to-face discussions and meetings with video conferences, for example. And as an employer, you should facilitate working from home wherever possible. We get to the details of this topic later in this webinar. If working from home is not possible, then precautions must be taken. People should come into contact with each other as little as possible. It may be sensible to involve a works council as well if you have a works council set up, if only to create support for your measures. When regulations with a sustainable character are introduced, or measures have a far-reaching consequences, despite the temporary nature of the measures, then the Works Council sometimes has the right to approve your measures, for instance, when it gets to working regulations or working conditions. What are now the consequences if this duty of care is not complied with? If the employee suffers damage during his work, an employer can be liable. So there often is a so-called reverse burden of proof. The employer must, in that case, prove that he has fulfilled his duty of care. With respect to corona, in the most extreme case, this can lead to illness and death of the employee. It's also possible that the employer receives a visit from the Ministry of Social Affairs and Employment, which is the formal labor inspection. This inspection can impose a fine or even stop production in case you really made a mess of all your safety measures. This will not happen all of a sudden, and you usually get a warning before this happens. Well, less serious, but although certainly not desirable, another consequence of not adhering to the duty of care would be long-term incapacity for work from your employees with all associated costs, not only continued payment of salary, but also, for instance, replacements, involvement of company doctors, and other costs. Any questions on this topic? I don't think so. I don't see any questions in the group chat, so I'll move on to the next topic. Ebe and Reorganization. This is an arrangement in Dutch. It's called the Noodmaatregel, Overbruggingsregeling, Werkbehoud. I think the English translation, there's no official English translation, but it's an emergency bridging effort that enables employers to continue payment of salary, and they will get a substantial contribution towards the wage bill by means of an advance payment in first instance. How this works is that you can apply to this, I will call it the now arrangement, because that's, I think, works better for everyone. So you can apply to the now arrangement for a period of 3 months, for a possibility, with a possibility of an extension for another 3 months. And what's the condition that you should meet is that you have an expected loss of turnover, so not profit, but turnover, as from the 1st of March 2020. What is then the benefit, and what is the government grant employees in that case? A maximum of 90% payment of the total wage bill in the event of 100% loss of turnover. That's quite significant, right? So if you have zero turnover as from March 1st, you get 90% of all salaries compensated. If, for instance, you have a 50% drop, then you get 45% compensation, and so forth. So it's related to the turnover in first instance, and then you get a compensation of your wage costs. There's no cap. So usually with these kinds of efforts, these kinds of measures, there's a cap of the maximum daily wage, meaning that not like the significant salaries above, let's say, 5,000 euros gross, they're not compensated, but even those salaries, so even if you have a CEO with a salary of 15,000 euros, his or her salary will also be compensated because there's no cap introduced. This measure also seems to apply to very prosperous companies that, although they suffer a lack of turnover or decline in turnover, they still would achieve a considerable turnover, and they might have, they might have low costs. So they, although they suffer, they still have a lot of profit. So this is really it's like a rough measure, right? So it's not very well thought about in the sense that misusage is possible. So it's really a measure that emergency measure. I see a question popping up. Let's see. It's a question on a full-time employed contract. BTW. Okay, we'll get to that later, Angelica. This does not apply to subcontractors. So, Ethan, this only applies to employees. We'll also, this arrangement applies to employees only, to your wage bill, and the invoices that are paid to contractors, they do not add to the wage bill. What we can do, what employers can do in relation to subcontractors, we'll get to that later in this webinar. So going forward, how to calculate a decline in turnover. So based on the application, the UWV, the governmental institution, will provide an allowance of 80% of the expected loss of turnover. So if you have, say, if you lost all your turnover and you would get a 90% compensation, you get 80% of the 90% in first instance. After 3 months, it will be recalculated. The question is really, well, one of the questions is, should you relate this decline in turnover to, for instance, January or February, the months January or February, or should you, for instance, take into account the whole year of 2019 and compare this with March 2020? There's no details introduced yet with respect to this topic. So the government basically says a decline in turnover, but hasn't provided us yet with details. This is expected to take place within, I think, 1 week from now. I see another question popping up. Do you know the loss of turnover needs to be compared with the reference point? That's exactly is the question. We don't know yet, but that's expected to be communicated by the Dutch government within roughly a week from now. So one thing is the reference point. Should it be a couple of months before the 1st of March? Should it be potentially the whole year of 2019? We don't know yet. But it is advisable to have your finance department make a couple of calculations to show that it's easy to produce once the measures are introduced in more detail. Another thing that is not yet clear is how you should measure the decline in turnover. Should that be on the basis of the invoices sent to your customers, for instance, or should it be turnover received? because there will be a difference. There's expecting to be a difference between the two of them in these times of crisis. I think many of us will agree that it's advisable to keep the economy going as much as possible and pay your bills, because that keeps the system going. Yeah, but every now and then companies will run into situations where customers simply don't pay. So should you take into account the invoices sent, or should you take into account invoices actually paid? It is also something that we expect to be included in the detailed arrangement. Let's see. Is it possible then to fire people during this arrangement? One of the conditions that's part of this arrangement is that you should not fire people on the basis of economical reasons during the application, right? So if you have applied to the now arrangement, you've been granted, you cannot fire people for economic reasons. So it's intended to bridge a certain period, retain employment, and to provide relief to employers with regards to the wage costs. It is, although, possible to dismiss people employees on the basis of other reasons, personal reasons. So, for instance, a breach of trust, culpable behavior, underperformance. That can all be valid reasons to terminate one's employment. Another question on the calculation: does one calculate the decline for the full period, or will there be a way to adjust? That's a good question. It could be that you get a decline in March and then it's maybe recovered in April. Yeah, we don't know yet. Sorry, that's not something. Yeah, we don't have all the answers yet. I'm afraid. There will be I think if you look at the arrangements, I expect this to be you have to add all the turnover over the 3 months and then recalculate. So on the basis of the total turnover, not for each month. So I don't expect there to be a calculation for each month separately. Dismissals, we talked about that. Now, if you have already applied for short-term working, that's possible, but that was possible until a couple of weeks ago. Then if your application has not been granted yet, then it will be automatically converted into an application to the now arrangement. If you have already been granted short-term working, then that will be applied for the initial period that it's been granted for, and then afterwards you can apply for the now arrangement. Ethan asks, what about a change in business needs as a result of the corona situation? Can contracts be changed? That's a question that we'll get to later when we will discuss the adjustment of working conditions, employment conditions. But the idea is that you won't fire people for economic reasons during the now arrangement, and indeed this leaves room to adjust employment conditions. Special groups and the Works Council. Will there be compensation for sick employees and flexible employees? Yes, there will. So your sick employees on the payroll that you're obliged to continue payment of their salary for at least 70% or more. You can add that to that's added to the wage bill and compensated for in accordance with the now arrangements. Also, flexible employees are compensated. So also the people on 0-hour contracts or min-max contracts are also compensated. Now that works. Nick will get into a little bit more detail on that topic. The role of the Works Council then with respect to, there's a typo I see, apologies for that, respect to the request. I don't know if there's any representation in the webinar of companies that have a Works Council, but you should know that in principle, you don't have to ask the Works Council for advice or consent with respect to these application for the now arrangement, it is advisable to involve the Works Council, at least to inform them on what's happening, and that this of course has an impact on the workforce, and potentially, yeah, of course, it blocks dismissals for economic reasons for a significant period. So yeah, people will generally be happy that this arrangement is asked for. Let's see. So you can decide on to reorganize rather than to apply for the benefits, the state benefits. This is possible in case you fulfill any of the criteria set forth by the UWV. So that can be a decline in turnover, that can be basically the wish of an employer to close its business in total. But the criteria are rather different than the application for the now arrangement. You would have to take into account that with bigger organizations, you have to involve the Works Council, potentially also the unions on the negotiation of a social plan. You have to run through the application system of the UWV. The proceedings, they take a couple of months to complete. You cannot select your own employees for dismissal, but you have to apply the so-called principle of reflection, meaning that within each age category, you look at certain positions and you spread the dismissals over these age categories, rather than to say, well, I'm reorganizing and I would like to retain my best employees. So that is a hurdle that you should overcome. Plus, in the end, you'd have to also pay the transitional compensation, at least to the involved employees. So this is, if you look at scenarios, I would say this is something that you recalculate before you decide on or either to reorganize or to apply to the now benefits. Let's see. Another question that came up during a previous webinar: can we dismiss an employee on a permanent contract position because of a collapse in business? Or is it only possible by short-term working or the now arrangement? Well, you can choose. It is still possible to dismiss an employee on a permanent contract if you fulfill the criteria set forth by the Dutch law. But if you have applied to the now arrangement, then you cannot do that anymore. There are a couple of examples relating, for instance, to the probation period, and that will be discussed by Nick later on. That was what we've wanted to share with you on this topic. As said, we expect that the government will be introducing more detailed arrangements in a week from now, and then we will schedule another webinar on those arrangements, because we expect that still will leave a number of questions unanswered, and we would like to share best practices with you at such point. There are questions that are not answered yet. We will get to that later in this webinar, and if not, again, we will look at that at a later stage after the webinar and send you an additional email. I will now move over exactly 1.5 meters, or perhaps a little bit more, to give the room to Mick. Thank you.
Hi everyone, thanks for joining us in this webinar. I will talk you through to some topics relating to sick employees and employees in abroad, and the privacy related issue during the corona crisis. To start with sick employee, what to do in case the employee is infected. A simple question to start with: before an employee is tested in the Netherlands, there's probably already a case of serious sickness. An employee who has been tested for the virus and is infected will therefore be incapacitated for work. This means that the employee is entitled to continued payment of wages during illness, which is in the Netherlands at least 70% of the normal salary, and it might be increased to up to 100% if that is agreed in the collective labor agreement, for instance, or in the employment agreement. The company doctor will also has to be informed if there's a situation of a sick employee. What in case the employee has mild complaints? At this time, everyone in the Netherlands must stay at home with complaints such as a cold, a cough, sore throat, or a fever, the mild complaints which might relate to the corona, the COVID virus. If the employee is still able to perform his duties, but cannot leave the house due to these mild complaints, he's expected or she's expected to work from home, just like every other employee in the Netherlands. The mild complaints do not make that the employee is sick for work. And the employee might be asked to work from home then just like any other employee. Martyn will come back to the home working situation later on in this webinar. An employee who's been abroad is an employee entitled to salary in case she is stuck abroad because he's not able to travel. And what if he gets sick over there? An employee who's abroad and gets sick is entitled to payment during sickness. That was the situation before, and that's still the situation. We can, however, expect that employers might ask from their employees not to travel anymore, at least not to travel to so-called high-risk countries. You cannot forbid an employee or prohibit that an employee is still going to travel, even to travel to a high-risk country or a high-risk region, but you can inform the employee beforehand that if he's going to travel to a high-risk country or a high-risk region, and he's quarantined over there, or he's getting sick over there, that it might influence his payment. For instance, that you will not pay salary above the 70% in case of sickness, or that you will that it is at the risk of the employee if he is quarantined abroad, and that in that situation he is not entitled to salary at all. If you inform the employee beforehand, then he knows what risk he's taking by going abroad and going to a high risk country. It's not said that such a measure will be upheld in court, but at least you have informed the employee beforehand what his risk is by going to a high risk region or country. A question by Corina is, and if working from home is not possible, what about pay 70% or 100%? If working from home is not possible at all, and the employee is sick, then the normal arrangements regarding sickness apply. However, at the moment, the moment, and for mild complaints, it's also prohibited to go to work. It's even prohibited to go to work if someone, a partner or a child, has complaints. And in that situation, so there's no case of sickness, but the employee is not allowed to come to work due to the measures of the government. We expect that the employee is entitled to his normal salary, because it's by government that he's not entitled to go to work at all. So we expect that the employee is entitled to just his regular salary. What if the employee returns from an area where the virus is widespread? In that case, it's not you're not allowed to deny the employee access just by the mere fact that he's been in such an area. However, if the employee has mild complaints or is sick, then uh, as of last Monday, it is allowed to deny the access of the employee to the workplace. Before Monday, it was not allowed to ask um, an employee what his complaints are. That was prohibited by our Dutch authority, privacy authority. But since last Monday, it changed its regulations. It's changed the way the regulations are explained by the Dutch authority, privacy authority. And now, during the Corona crisis, it's allowed to ask the employee what his complaints are, and if those complaints are Corona related, then it's allowed to send the employee home. Is it possible to impose a travel restriction on employees? I more or less answered the question, just the question before. It's not allowed to impose a travel restriction. That's a privacy related issue for the employee, and it's his decision. You can, however, inform the employee beforehand that consequences might be taken if he's going to a high risk country or a high risk region, but it's not allowed to prohibit an employee to go to a certain destination. The next question of Corina is, but if it would be a family member, then you can rely on short care leave, or would you say that also in those cases companies should pay 100% based on the argument that the government said that such employee should stay at home? Yes, I've thought about this example for the last 2 days, because in a normal situation, if you have a sick child at home for which you have to take care of, you have to take the short-term care leave, and it's against 70% of your regular salary. In this situation, for instance, in a situation with a two-parent household, it might not be necessary that you stay at home to take care of the child, but you are obliged to stay at home because it's not allowed to go to work in case you have a sick child at home. And what is then applicable? The 100% salary because you can go to work because you don't not have to take care of the sick child, or the 70% ruling because you have to take care of the sick child. It's a very typical situation at this moment, which we have never had before, because it's the first time in the Netherlands that under certain circumstances you're not allowed to go to work. And I would say that a smart employee will say, well, yeah, I would not have, it's not necessary for me to take care of the child, but he's sick and now I'm not entitled to go outside my home. So yeah, it's not that I need to take short-term care leave, but I just can't come to work now, and then I'm entitled to 100%. So I don't know if it's really going to work out like this, but I can expect that an employee who has a bit of a feeling about how to twist and bend the rules, that he's applying for 100% salary during that specific time, this specific times. Is it possible to ask your employee if he recently returned from a high-risk country like Italy? It's still not allowed by the Dutch privacy authority to specifically ask where the employee has been on a holiday, but we can assume that you ask it, or at least ask if if he has been in a high-risk country or high-risk region. And 2 weeks ago, almost not every country or not every region in Europe was a high risk country. At the moment, there's a lot of high risk regions at least, and we might expect from a company that you ask the employee if he has been in a high risk country or region. Ethan Holmes asks, is there a certain number of days that an employee must stay at home once being sick or exposed to someone that is sick? Well, that's a good question. Um, it's not it's not the 14 days home quarantine. That's something I've not read. Um, as far as I'm aware of, if someone is safe for does not have any mild complaints for more than 24 hours, it's allowed to go outside again. So that's also um, it's also applicable to the other people in the household, I assume. Can I ask an employee what kind of complaints he has? Till last Monday, that was not allowed by our privacy authority, but it changed the explanation of the GDPR and says for this specific times, for this corona crisis, it's allowed to ask what kind of complaints the employee has. And if those complaints are corona related, then you are allowed to send the employee home and ask the employee to see a doctor. That's really new. That was not allowed before last Monday. Another question by Corina. What about employees who are not sick or incapacitated for work but are vulnerable in case of CPD or a heart condition? Do we need to send such employee home or not if working from home is not possible? And if so, you have to pay full wages or treat such case as a sick case. For the specific vulnerable people, also the vulnerable employees, it was already advised that they are not coming to a working place. So that's not that has not changed since last Sunday. That measurement was already in place. So for such an employee who's falling within the vulnerable cases, he has to stay at home. And if the company cannot provide working from home, that falls most likely within the risk of the company. And then the employee is not sick, but he's entitled to his regular salary because the company cannot provide the work from home at the moment. To what extent is medical testing possible? What are my options in this case as an employer? This also changed since last Monday. It's still not allowed for an employer to test. It still is has to be done by the company doctor. If you want to have the testing on your sphere of influence, but you may now ask the employee to test him or herself. And that's also really new. That was not allowed before last Monday. You can now ask the employee to, for instance, measure the body temperature. And if it's above 38 degrees, you are allowed to send the employee home. That's really new. That's really interesting stuff, actually, because that has never been the way it was before. What if the partner or an employee's child is affected with the coronavirus? That changed since last Sunday, and we've discussed this topic. The employee is not allowed to go to work in case of a sick employee or a sick partner. How to handle the reintegration of employees? These are the non-corona related long-term sick employees. The reintegration has to be performed as much as possible from home or at the company, but most likely from home. So it's not allowed to fully stop the reintegration during this corona crisis, but it's not expected impossible from an employer. So if it's not possible to adjust the work in this situation for a sick employee, then it's not expected to do so. But you have then you need to change or amend the action plan in which you explain why during this corona crisis there's no reintegration activities, or during this corona crisis, the reintegration activities has been changed to modify with under this specific circumstances. So adapt this in the action plan that you can show the UWV later on, that you have thought about this, and that you have taken specific measures to make sure that the reintegration process is going on during this corona crisis. This was my last question of this subject. If there are no other questions, then Martyn will continue with the working from home.
Yeah. Here we are again. Duty, is it, when can you oblige employees to work from home? Well, under the current circumstances, this is almost always possible. The guideline is working from home as much as possible. This is simply an implementation of the duty of care, and will certainly apply with people who have mild complaints, or as stated previously, people with family members who have complaints. So there's a precautionary measure there as well. Question is, can I also oblige employees to come to the office? This is not so much a question that arises in companies that have offices, rather than the companies with factories and production facilities where basically you cannot work from home. So this is something, the straightforward answer is, if the production process requires people to come to work, then you can oblige an employee to come to work. And naturally, the essential precautionary measures with respect to hygiene should be taken at the factory or at the office as well. But what if an employee doesn't want to come to the office? In this case, discussion will be, well, we need you. You cannot work from home. And the employee may say, well, I'm frightened that I will get the virus to be infected, or that that I'm going to be affected. This is not a reason, according to Dutch law, this would not be a reason to not come to the office. Fear of getting infected is not a reason not to come into the office. However, like Nick already mentioned, the question is how employees will be, some of the employees will be responding to this topic. If they say, well, actually, I have one of my family members is having a cold, yeah, then you should send him or her home. So it's more or less, well, I would say it's more, it really is a topic that you should discuss in a positive way with employees, and not in a demanding way, because if you do that, it's highly likely that employees will find a way out and possibly fake a cold or fake a family member with a cold. It's something you would like to prevent. See. Yeah. Can you adjust employment conditions? And one of the questions this was raised at earlier stage as well. Are you adjust the working hours? Working hours are employment conditions. Employment conditions you cannot simply adjust in accordance with Dutch law. You need, there's people who've written lengthy books on this topic, but the basic idea is that you need a heavy weighing ground to do so, and that there will be this heavy weight ground will be balanced with the interests of the employee. The impact of coronavirus definitely would qualify as a heavy weighing ground to just working hours, but you still need to have to take into account the interests of the employee. So, for instance, the interest of the employee to combine the care for children with work, but also, for instance, the Working Hours Act. If you would require an employee to work during nighttime, The weekends, it's possible, but it has you will run into restrictions based on the Working Hours Act, and you cannot ask that for weeks on end. There should be time to recuperate, and detailed rules are included in the Working Hours Act. And English versions of these rules are found at the internet as well, the government websites. But in general, our view is that requesting the employees to spread their working hours over a day is a reasonable request and can be required by employees. Now, how about the work? Can you adjust work? Well, this, for instance, could apply to restaurants, right? The restaurants have been closed on the basis of measures, governmental measures. Can a restaurant owner ask their employees to come into, not into the restaurant, but into the warehouse, for instance, to clean it up, or to basically do some work at the background? Yes, that is possible. And again, the Corona crisis demands a great amount of flexibility, both for on employers and employees. So our view is that you can ask this from employees, and we have seen many examples of people having to come in to basically do some cleaning work, or be involved in, for instance, the administration, where they would be in a totally different position before. So you can temporarily adjust people's jobs as the impact of the virus on employer becomes more acute and more serious. You can ask more from your workers, especially if an adjustment of work is implemented to avoid redundancies. Let's see, there Ethan asks, when factoring payroll to employees on a min-max contract, do we pay the min or the max or an average? I think I'll get to that, Ethan, on one-on-one with you, because I know your specific circumstances. Let's see. This is discussed by Mick. The lack of daycare. This is a topic that is really something that a lot of employers have problems with, basically grasping it and also implementing it. What if an employee cannot work at home because of problems in the daycare? So schools closing, grandparents who cannot come because they are in an old age and from a risk category, or partners who execute a so-called vital profession, such as in healthcare. This is a difficult topic. If you would take a strict legal approach, you can say, well, in principle, employees could make usage of emergency leave, calamiteitenverlof, that it's a couple of hours until a couple of days to make arrangements, for instance, to arrange for the care of children. This leave applies to solve a certain calamity, right? So it will not be applied for days on end. There is a limit that is generally a couple of days, and after that, unless the child is ill, in which case a short-term care applies. After that, basically you can say, this will come for the risk of an employee. If you cannot solve your care situation at home, then you're not entitled to salary. This is something that is quite harsh, I would say. So the question is, does this apply to every company in the Netherlands? Most of our clients take the view that they first ask for flexibility, right? So they check with employees, well, when can you work? last week has been a period where there was just making ends meet and implementing the work from home situation. In this case, well, after the calamity leave has lapsed, you can also look at, for instance, the output of employees, and you can say, well, if you can, normally you would work for 8 hours per day. Now you can do only 6 hours. As long as your output is okay, you will pay your full salary. Or you can take a middle position and say, well, you can work for 6 hours, whereas usually you would work 8 according to your contract. So we suggest that you take up some holidays, or that the difference is unpaid leave, qualifies as unpaid leave. Couple of options you have here, and depending on your situation, you can choose what is the best approach. Question. I see a question coming up. It's about holiday balance. Allowed to ask employees to take some days from their holiday balance to meet personal needs. You can ask it, but it's not up to the employer to determine the way or the moment where people take up their holidays. So it's a request you can make to the address with the employees. Is it advisable to discuss with the Works Council? Yeah, could be. Could be too, but you really have to think about the different scenarios that you will present to the employees. Generally, I would say I haven't seen many companies that discuss this with the Works Council. There's no legal obligation to do so, but again, it could be advisable to do so to create support for your measures. So I think this would be look at the specific company situation. Can you check whether employees are meeting their working hours? Can you monitor employees? Well, basically, monitoring is not allowed unless you have a legitimate goal and the means used are proportional. So generally, micromanaging employees, micro-monitoring everything they do on their computer is not allowed. Monitoring, usually it is implemented in a so-called ICT arrangement, and the employee must be informed of what is processed in that case. Usually it's about making sure that the network is protected against viruses and that certain things are monitored in that case. For instance, we would advise to monitor the actual output of employees rather than to implement software applications monitoring their everything they do on their computer. Question of Ethan, what about holiday bonus payout in May? That we will address to that specific topic later on in the webinar. Because, it's a thing that has been asked many times. So monitoring, we should just discuss this with employees. Make sure that there is good video conferencing in place. Have regular meetings with employees and ask how they are doing. So steer on the output rather than micromanage with a monitoring system. We've talked about the consequences of wages. A couple of things that are also really relevant is how to organize this. What do you have to do to arrange working from home? So in addition to a number of practical matters, such as establishing a secure internet connection, an account for video conferencing, etc. It's also good to make arrangements with each other in a so-called work from home agreement. They would put things, they would include things on how to deal with reporting, accessibility, and also furniture to be used, etc. And it seems it is advisable to involve the Works Council in this case, now that the scheme will probably, the work from home agreement will probably also be containing provisions with respect to working hours. And certainly, in case you would monitor the employees to a certain extent, you have to obtain the consent of the Works Council. What obligations do you have towards the employee if he or she works from home? Well, this is something that you should be very much aware of. If you would go back to the duty of care, it also applies to working from home. There's a case with the pension insurance company PGGM of 2007, where PGGM was held liable by an employee that has worked from home for a couple of months and had complaints further to as a result of using furniture that was not up to standard, so it was not ergonomically approved furniture. PGGM was held liable by court, also in higher instance. So this could have, and this was quite impactful. Now, often this is not so much of a problem because in the pre-corona era, I would say, most employees did not work from home for days on end, right? It's usual for most employees, it's something they do every now and then. So the risks of incurring RSI are quite low. But nowadays, people they are likely to work from home for a couple of months in a row. So there is a significant increase in risks. So what do you do? To start off, at least, with an instruction to employees regarding the usage of furniture and the way that it should be set up. So it's quite obvious that you should not allow people working from home on the furniture, on the couch, with a laptop. They should have a decent desk, decent chair, and you all probably know the pictures and the advices, the guidelines set by ergo specialists with regards to the height of this desk and the height of the chair, etc. So at least do that. Include a checklist and ask employees to fill in a checklist and check if their furniture meets the standards. In case it doesn't, then it is advisable to basically amend that and to provide the employee with furniture that does comply with the standards. There's no minimum or maximum amount that you should budget that you should include for this. This is not set by law that it should be, for instance, 500 euros or 1,000 or 2,000. Josephine says that sounds totally not realistic for some people who have small kids and a small living space. Agreed. I can't agree with you more, but it doesn't mean that that you cannot do anything as an employer. And you still can, if you ask employees to work from home, you still have an obligation. You can also say, well, if you don't have the correct furniture, then you shouldn't work from home. But I think most employers would not choose that option. Even in a small living space, you should look at the possibilities to create a situation where people can work safely from home. And if still it's impossible, it's a risk. It should be highlighted. And if you're in HR, I think your task to highlight this with management to see what you can do. That with regards to working from home. Question: is there a way, I see in the chat, is there a way that the employees buy the table or chair that is needed and get some tax benefits? Well, it's basically it will be at the cost of the employer, and there are some tax benefits in the sense that it can be provided at you don't have to pay wage tax over the amount that you invest, but you can also use a construction where the company, the employer would invest in the furniture, and that will be returned to the company afterwards, for instance. You may be able to use the office furniture, and then the cost will be limited to moving the furniture to the employees' homes, for instance. You can check the accountant for check with your accountant for the exact taxation of these arrangements. I'll now again move over and give the word to Nick for the last topic of this webinar.
Hi again, everyone.
Sorry. So, okay, we're back. Yeah.
All right. Oh, sorry about that. For us, it's also still a bit new, the webinar applications, and it might happen that we get a phone call during this webinar. Excuse us for that. We will make sure it will not happen in the next webinar. I will go to some different various topics relating to this Corona crisis. The first one is how to terminate contracts. Can I terminate the employment contract by invoking the probation clause, even if the contract has not yet started? Yes, that is possible. A legally agreed trial period, the probation period, may be invoked. The clause may be invoked. The authority to use the probation clause is very broad for an employer. The probation clause may also be used if the contract has not started yet. It therefore seems sensible to inform the employees who are going to start at the 1st of April or maybe even at start of 1st May, and you have a valid probation period in the contract, that you inform those employees that you are not going to start the contract and that you invoke the probation period clause. That is a possibility at this moment of time. A sidestep from Corina: what if both parents with non-crucial professions work in a factory and thus one has to stay home? What will be the pay arrangement then? So both employees work in crucial professions, and one has to stay at home to take care of the children who do not go to school at the moment, and there's no other solution to take care of those children. Well, schools or daycare is open, as far as I know, for parents who work in the crucial professions. So those parents are entitled to bring the children to daycare. So that would be the solution, I presume. Oh. Non-crucial professions. For non-crucial professions, sorry, I misread that. For non-crucial professions, yeah, if both parents have to go to work, for instance, because they work in a factory and they can't take care of the children, then, or at least one has to stay at home for the children, then that employee has to take vacation days or unpaid leave or make a certain arrangement with the employer, because yeah, you're not entitled to stay at home to take care of the children as long as they are not sick. So yeah, if the employer is very strict about this, then it might of course be that the employee calls in sick with corona-related problems, or that he claims that one of his children is sick and that he's therefore not allowed to go to work. So it's not, I guess, very wise to push an employee to go to work if they both work in non-crucial for non-crucial employers, but are having problems to take care of the children. Josephine says have to step out. Thanks, guys. Really helpful. Okay, she's probably out already, but you're very welcome, Josephine. Do I still have to call on? Do I still have to call on-call workers? The stimulation measures, which Martyn discussed, are also applicable to the wage cost of flexible employees. This is an improvement for employers compared to the former reduction of working hours scheme, the Werktijdverkortingsregeling. The government therefore urges companies to continue to pay the usual wages for flexible employees. The wages to which an on-call worker may be entitled are highly dependent on the on-call worker situation. The legal status of an on-call worker is quite specific. It might be a 0-hour contract or a min-max contract. Martyn discussed it a little bit earlier, and when we discussed this for the first time, we could come up with several different case topics which all have a different outcome. So if you have on-call workers at your company and you have specific questions about if you have to call them, if you have to give them work and what their entitlement to salary is at the moment, please contact Martyn or me directly and we will answer your questions, because it's highly dependent on the specific situation of the flexible worker at your company. Can I terminate the contract with a self-employed person? Under Dutch law, self-employed persons, a ZZP'er or zelfstandige, do not have the same legal protection as employees. The mutual rights and obligations are stipulated in the contract between the parties. So you have to check in the contract if there's a notice period applicable, or for instance, a guarantee of turnover or hours per month. If such a notice period or such a guarantee has been applied in the contract, then you should observe that notice period or that guarantee. Also in this situation where there might not be sufficient work. If there has been not agreed a notice period and parties work for a contract for indefinite period of time, the reasonableness and fairness between contract parties might oblige the company to also obtain a certain notice period, because that's based on case law. And during a notice period, it's not allowed to not give the self-employed worker no work anymore. So it's not possible that you guys agreed on a 3-month notice periods, for instance, and that the self-employed person worked for, let's say, 10 to 12 hours a week during a certain couple of months or years even, that you say, well, during the notice period, we don't give you any work anymore, because that's not in line with how the notice period should be applied. You can, of course, decline the amount of work, so it might become less and less for during those months, but it's not allowed to go from 100 to 0 within a day, for instance, or within a week. A question by Ethan: does a non-Netherlands-based contractor apply for support in their country or residence? Country of residence or in the Netherlands? That's a very good question. I don't know if the non-Netherlands-based contractor might apply for the stimulation package for this specific type of workers in the Netherlands, or that he has to do it in his own country, country of origin. He has to check that himself, to which stimulation package he can apply. I don't know that by head. Can we oblige employees to take holidays if they also take care of the children at home? Martyn and me, we've explained this question a bit already. It's not possible for an employee to oblige employees to take vacation days. You can request at this moment to take vacation days, also in the situation that the employee does not have to take care of children or a partner, but just for everyone to chip in a little bit in this crisis. It's possible to ask the employee to accept that, but it's not possible to oblige it to just set it yourself as an employer. Can I refuse a holiday request? At this moment of time, most likely not a lot of employees will ask for a holiday, but we expect that if the business starts again, which might be during the period of the summer holidays, that a lot of employees will take their regular vacation during that period, and that's the same period in which the company tries to restart business. We can assume that the company might send an email beforehand to employees at the moment that it's likely that the business will fully restart again, that you guys are going to apply the rules on vacation a little bit stricter, and that if in a certain period of time and a certain amount of employees request for vacation, that the company has compelling interest to reject the application for the vacation due to this very specific period we had with the corona crisis. So if you anticipate on this, if you anticipate on the fact that employees might ask for vacation during the summer months, which is most likely the months in which the business restarts again, then anticipate on that, send an email beforehand that you guys are going to be stricter about vacation applications. Can the employee still change an approved holiday? There's case law about this subject, and approved and established holiday is in principle fixed. However, unforeseen circumstances, such as this corona crisis, may prompt the employee to submit a request to change the vacation request. The employer will have to act as a good employer to such a request. In my opinion, in our opinion, that would mean that the employer will have to cooperate with the request for a change unless there are compelling business interests on the part of the employer to refuse the change. Giovanna asked, what if, because of the situation, we have to cancel holidays and want to postpone later in the year? Could the employer refuse, and should employee still take holidays as first agreed? Oh, that's exactly the question I just answered. So you can request to change the set days for the vacation, and the employer, as a good employer, has to consider your request. And in our opinion, only in compelling business interest, the employer might reject such a request. Compensation. Can I cancel the travel allowance? Corina, in some cases, companies have some fixed holidays between Christmas and New Year, for instance. Can you change those bases on good employment or other legal entrants? So that's the situation that the company says, well, we have in our contract that we might decide, for instance, a week between Christmas and New Year that we are closed, and those days should be taken as vacation days. It's questionable if there's a prompt legal basis for it. There's a legal basis for it to unilaterally change that for this period of time, that you say, well, we close next week and you have to take vacation days for it. But we can expect, and the same goes with the travel allowance I will discuss now, that employees will not much protest against it because most employees understand that they have to chip in a little bit in this situation too. But if they are complaining, if they do not accept this, they have probably a more stronger case than you as an employer. Also, if you have in the contract stated that you might unilaterally decide on a certain period during a year for a fixed holiday. Giovanna asked what compelling reasons are. Those are compelling business interests. So if there must be serious business interest at stake if you want to reject an request for a change of vacation dates. So it's a very high bar to reach. Can I cancel the travel allowance? To cancel the travel allowance, it might be based on the employment contract or the policy regarding the travel allowance. If you have, for instance, stipulated that after 2 or 4 weeks or 6 weeks or of inactivity, the travel allowance might be stopped, then you can use that basis to stop the travel allowance at that moment of time. Also, the tax authority says that you have to stop the travel allowance if the employee stops traveling for work. So if the employee works from home since last week, you're allowed to complete this month. Also give another month, so next month, the travel allowance. But if you continue to pay the travel allowance after that month, so in this situation after May, then you will be taxed for it, because then it will be seen as regular wages. But what we hear from our clients is that they say, well, we just stop travel allowance as of the 1st of April, for instance, because we expect that the employees understand that if they do not travel anymore because they have to work from home, that they are not entitled to travel allowance. And yeah, if there's a legal basis for it, okay, we might not have it in our policy or an employment contract, but we just decide this due to the fact that the mere fact that they don't travel, so they are not entitled to travel allowance. Can short-term leave, care leave be compulsory? Now we have discussed that a couple of times now during this session. Can holiday allowance be paid later? That was a specific question in the chat as well. That's only possible if it's agreed upon with the employees. And one of the biggest unions, or the biggest union in the Netherlands, the FNV, has said that it's willing to cooperate with employers to come to arrangements to pay the holiday allowance later on in the year, if the payment now makes it uncertain for the employer to stay open. And for instance, in the horeca, in the bars and restaurants, it's very pregnant at the moment. And then the FNV has said, well, we are open for discussions to discuss to pay the holiday allowance later on in this year. Amanda asked, can we cite low group results at the end of year and or solidarity with other group members who experienced bankruptcy during the year as a reason not to pay employee bonus in 2020, if these have always been paid against achievement of specific and personal KPIs? It really depends on the arrangement in the bonus scheme. If you have a discretionary authority to decide whether you pay a bonus, then there's a discretionary authority to decide that. Also, if some KPIs have been achieved. But it's maybe a little early already to discuss this topic, because we really have no idea how 2020 is going to work out. Everybody might expect that the bonus schemes will not be made, the targets will not be made this year, but we have to see how it works out. So Amanda, if it's, let's wait and see a little bit longer how this works out. And if you have this specific question at the end of 2020, if at the moment the bonus has to be decided, if people are entitled to those bonuses, please contact us again, and we'll advise you if you are entitled to pay this bonus, or that you have, for instance, a discretionary authority not to pay the bonus, even if some targets are met. This was the last question, which is Martyn has already discussed. Can I temporarily assign other activities to employees? I will not go into that anymore. That was my last item. I don't see any questions anymore in the chat. So then I will go 1.5 meters away from this computer, and Martyn will formally close this session with you guys. Thank you all for joining us today.
So everybody, yeah, again, thanks for joining. As stated, we have recorded this webinar and we will distribute the recording through email. We also include possibly a short survey, because of course we'd like to improve our webinars. We expect to give a lot of webinars in the future, not only on the Corona crisis, but also on other aspects of employment law. On short notice, there will be another webinar as soon as these measures, so the now arrangement has been set in place. So you can expect an invitation to attend that one sometime next week. Thanks again. Hope you have enjoyed it and found it helpful.